evening, ladies and gentlemen. Welcome to the second in a series entitled Conversations with the Judiciary. My name is Sanile Sibanda, and my job is a very easy one. It's just to introduce tonight's particular conversation and to introduce our speakers, explain the format of our conversation, and then we'll get things going. I'll keep it brief because we've come to listen to our very esteemed guests. But just a little bit of an explanation, of a few words about this series of In Conversation with the Judiciary, is that we at Wits Law School have decided that we want to create a platform where judges from our various courts and other interlocutors and other commentators in constitutional law come from time to time to speak to us about contemporary legal topics. And this is really to give members of our courts an opportunity to reflect on their experiences and share some of their thoughts with us on their roles as members of the courts, and really how our courts relate to our constitutional project and more broadly South African society. And for us as members of the academy or members of the public or members of the profession, it gives us an opportunity to interact with members of the court in a less formal and more personable environment. Well, certainly more personable than courts. So we must appreciate this particular opportunity and be thankful to the members of our courts and of course retired members of our courts who take their time to come and share with us. Now, the format of our conversation will be that it's split into two equal parts. The first half of it is a 45-minute conversation, moderated or led by Professor Mdende Hango with our two guests, Justice Kate O'Regan and Professor Stuart Woolman. Then the second part is going to be an open session where we get to put questions to our panelists. And in this part we ask that there be no monologues, no long statements, and we ask questions, or if we want to contribute to the conversation, keep our contributions brief and directed to what has already been discussed. And Mdende will make sure that he keeps everybody on track. Few housekeeping rules. Please, can we all turn off our cell phones? If you really must have it on silent, but it's quite distracting to our speakers and frankly quite rude to let our cell phones go off whilst people are engaging in conversation and sharing with us. The other thing is that if you need the bathrooms are out the back to, I guess, to the right, and then along the passage on the left-hand side. And then very quickly to introduce our two participants, our two conversationalists. Judge O'Regan is somebody who is familiar to probably all of us, so she has asked me to keep the comments very, very brief so that we can actually hear her thoughts and so she can share her insights with us. But very, very briefly, for anybody who might not know, Justice O'Regan was a member of the first Constitutional Court, so she joined the court in 1994 and retired in 2009. Subsequent to that, she holds a few positions, such as that of being an honorary professor at the University of Cape Town, a visiting professor at the University of Oxford, and she has most recently been a Hauser Global visiting professor at NYU. She sits on the boards of several NGOs. Corruption Watch is one. She also is involved in the South African Legal Information Institute, an important organization that provides law reports for us online for free, and it's something I know that in the law school use quite extensively. And she also serves as an ad hoc judge of the Namibian Supreme Court, and I hope that was brief enough. Professor Stu Woolman equally is somebody that should be familiar to all of us who have any sort of interest in constitutional law. He's the Elizabeth Bradley Chair of Ethics, Governance and Sustainable Development at the Wits Graduate Business School. He's the Academic Director, Colloquia and Research Director at SIFAC, which is the South African Institute for Advanced Constitutional, Public Human Rights and International Law. Stu has lectured here previously at the law school. He's also lectured at the University of Pretoria and Columbia Law School. Stu is extensively published, and as you will see, he's handed out a few examples of some of his upcoming work, which we believe will be very, very exciting, particularly the Selfless Constitution. Stu is a consummate marketer, as I'm sure you'll have realized. And we're really, really honored to have our two guests with us. And I hand over now to Mdende, who's going to moderate and lead our conversation. Thank you.
Thank you very much, Sunny. It's really an honor for me to have both of you as my guests and to chat with you in this fashion. I also would like to personally thank you, both of you, for agreeing to do this and for being here. And I would also like to thank the audience for being here to participate in this important event. And I want to start our conversation with you, Justice O'Regan. I think you are one of the first justices to be appointed to the Constitutional Court. And if my memory serves me right, you served in that court for 15 years. How would you characterize the role of the court during those many years that you served on that court?
That's a big question. I think one of the things that's very distinctive about the South African Constitutional Court was its role in the certification. You'll recall that when the political negotiations began between the liberation movements and the National Party government, an impasse arose about whether we were going to get a final text to be produced in these sort of backroom discussions that were taking place at Kempton Park, or whether we would get a constitution that would be drafted after democratic elections. And the solution to that impasse was in fact the genesis of the Constitutional Court, because the agreement was, well, that this first interim transitional constitution would have attached to it certain principles, which a final constitution, which would be drafted after the first democratic elections by Parliament sitting as a constitutional assembly, would have to comply. And then the agency to determine whether there was compliance was the Constitutional Court. And I mention that because I think it's both a symbolic and real example of how the Constitutional Court sits at the heart of our constitutional democracy. Not perhaps directing it, but certainly it is not an add-on, it's not an accidental part of it, it really was at the heart of it. And I think, it's quite simple what its role is. Its role is to protect and enforce the Constitution, which of course, as we all know, is a transformative constitution. It's a constitution which is going somewhere, which wants us to go somewhere, and the court has an important role in that. But I think that it's also important not to overstate, firstly, the role of the Constitutional Court vis-à-vis other courts, or vis-à-vis the other arms of government.
No, thank you for that. I was just thinking about the other courts, and if I would ask Stu this question, I'll let you answer that question, but I want to phrase it in this way: that you are well known, prominent commentator on constitutional law in South Africa. But when you look back all these years since the establishment of the court, how has the court fared in terms of giving guidance to the lower courts and maybe also to the other branches of government on constitutional questions?
I can see where your question's going, and I'm going to try to avoid it. You're picking up on the amazing Vanishing Bill of Rights article, where I said, I suggested, in any case, that some of the court's judgments using 39.2 as a vehicle had been too thinly reasoned to provide the necessary guidance for lower courts and for other state actors and for citizens to understand how they needed to conform their behavior to constitutional dictates. I was roundly criticized by Frank Michelman for that argument. He said I'd gone too far, that the court had not been engaged in a substantive flight from reasoning, and if I had just worked a little harder, I might have understood where the Constitutional Court was headed. That said, 5 years later, Professor Michelman, in a paper that's going to be coming out in the Stuart Law Review called Expropriation, Eviction, and the Gravity of the Common Law, both seems to have, well, I think the critical bite of difference between us is minor, but has his own questions about the thinness of reasoning and potentially an over-reliance on the common law.
But if I could just interject here, that I mean, Justice Oregon, I mean, is that a fair assessment of what the court, experienced since it was established?
Well, I think that this debate is very much about the Constitution and the common law or private law. And I do believe, I was present when Frank Michelman gave this paper. I haven't seen the written version of it. But I do think that he's correct, and I'm not sure I'm going to agree with Professor Woolman, but I do think that Professor Michelman was correct in saying that the court had been extraordinarily cautious about the common law when it was pretty aggressive about asserting the Constitution in the area of statute. And there's an interesting paradox there, because, of course, the common law is a creation of judges with not a particularly legitimate or democratic provenance, whereas much of the legislation that the court overturns is now the product of a democratic parliament. And why should the court be cautious about the common law and not cautious about legislation? I think there is one, as I say, I think there's that's an insight that I think has got some merit. But I've got one comment about it and one confess and avoidance. The comment is that I think that the court's caution about the common law may have to do with the split jurisdiction between the Supreme Court of Appeal and the Constitutional Law, and the Constitutional Court, which has left the Constitutional Court feeling, for very good institutional reasons, that it needs to be deeply respectful of the development of the common law by the Supreme Court of Appeal. And if you start with Carmichael, you see that in the jurisprudence of the court. It's going to be very interesting to see what the 17th Constitutional Amendment does to that, because, of course, now the Constitutional Court has got arguably jurisdiction over matters that it considers to be of great public importance, upon which its views will be helpful. I always think that's a terribly sort of arrogant thing for a court to have to say. But anyway, nevertheless, that's the test, the constitutionally set test. Right. So that's my one comment, is that I think that's perhaps one of the sources of it. The other is that in some ways the common law is a very tightly woven fabric, and it's not very easy to make a huge change in it. It changes incrementally in small ways, and very often when a piece of the common law is challenged constitutionally, it's a relatively full frontal attack which it's quite difficult to deal with. So let me take the classic example, which is the one probably on all your minds, and certainly on my mind when I sat in the Constitutional Court, and that's the principle of pacta sunt servanda. How are we going to write into the law of contract some sensitivity to constitutional concerns without fundamentally undermining pacta sunt servanda in a way that renders the clarity of the law, or destroys the clarity of the law? And so that's an example, I think, of how difficult the common law is. In my own view on that particular issue, is we need unfair terms legislation. We need to introduce unfair contract terms. It's really difficult to create that kind of jurisdiction on a case-by-case basis, and it's actually asking too much of the courts to do so.
Thank you for that. You wanna add a little bit?
Potentially one word or two.
Okay.
I mean, when Mark Tushman, who's a reasonably well-known professor of constitutional law, was writing about this common law, statutory law provision, he said it's pish-posh. Sorry, I think that's a technical term, it's pish-posh. But he said, look, statutes, they're civil law traditions, statutes are fairly dense, they're complicated. Just bear with me. Mark and I don't have to be right. But I think there is some merit to what he has to say. And he said there's no real reason for a court to defer to an existing body of common law, where the common law is judge-made law, after all, but not to defer when it comes to statutory law. Now, there's an interesting proposition, and I think it's starting, and it's one I haven't put in press yet, but you'll see this distinction happening again and again in constitutional democracies with apex courts like a constitutional court. It doesn't matter if it's Canada, the United States, Germany, or South Africa. What's fascinating is you see a willingness, whether it's a state action doctrine in the United States, or intermediate application in the German basic law, you see a willingness to intervene where there's statute at play, but less of a willingness in both Canada, the United States, and South Africa to engage common law. Now, it could be, Justice O'Regan could be giving the perfect answer, that it's just too naughty a body of law to kind of to decouple various cases from one another and come up with a clear rule that's to be preferred, or as I think Frank Michelman is intimating in that article and the paper he wrote, which I think was addressed to a particular justice sitting on the Constitutional Court, or the courts may over-valorize the common law tradition of which they're a part. But, having said those two things, I just want to add a third. Because I don't want to make it seem like I'm overly quick. Just quick.
Okay.
So I want to come back.
I want to move on to something more.
But I want to come back to what Justice O'Regan started with, because I don't want to come off here as being, a gadfly. That's not my role. Justice O'Regan started off by talking about the first certification judgment as the most important judgment, perhaps, that the court's handed down. And I think she's absolutely spot on when she says that. If you haven't read it,
why do you say that? Why is that the...
Well, I think there's a deep humility expressed if you read just paragraphs 26 to 28 about what the court's role is in a constitutional democracy. Right? At this very critical moment, it's being asked, is this constitutional text certifiable? Not in a crazy sense, but is it certifiable in terms of the constitutional principles or not? And the court says, and I think they're right, there's a distinction between law and politics. Our job is not to play politics.
Stuart, let me interject here and sort of bring in some of the contemporary experiences. You remind me when you're talking about politics and law that I think most commentators in South Africa have said that the country has become politically polarized and that there has been a lot of pressure brought to bear to the courts. And the question I want to pose is, is it a fair assessment to say that this political polarization puts any pressure on the courts' ability to function at all, or not?
I don't think it threatens the court's ability to function. I think that we must always be careful not to mistake litigation for politics, or as the terrain, the only terrain of politics. But I always feel, courts have a very clear role that they must play, and they must play it despite where the noises are. And it's very important. It's very important that courts do that. And I think that it's not only been around political contestation, but it's also been around, very difficult issues that have come before the courts. Relating to the charges against the current president, etc. These have all been very difficult times and processes for the courts. But by and large, the courts have just stuck to their knitting, kept us in the terrain of where they ought to be, and I think that's what the appropriate response for courts. It is important, as I often say to law students, though, your role is much more important as a citizen as it is as a lawyer. For lawyers, we can be useful, we can contribute to making a democracy, but actually it can't be the way in which we live our democracy. If we try to live our democracy entirely through the courts, we might as well walk back home. It's not the only terrain for democracy. It never can be.
Well, I get a sense that you are suggesting that the court's role should not be determined on the basis of the political necessities of the day. Is that a fair characterization of what Justice O'Regan is saying?
I always want to answer my own question, but I'll answer yours. First of all, yes, that's what Justice O'Regan is saying, and she's spot on again in saying so. She's also correct in saying 30 cases a year does not a constitutional democracy make. The action for governance of this society lies elsewhere. It lies in the governance of this law school. It lies in the various communities of which we're a part. But to concentrate despite the fact that I have a lot of books on the Constitutional Court, to make the Constitutional Court more important a player than it is a fundamental mistake. Now, there is something the court can do and has started to do, and I think it's an emerging pattern that could well bear fruit in coming years, so I argue, which is to create the space for bringing multiple actors into the room to try to hash out a problem, right? I mean, litigation normally is a binary process, right? It's adversarial. That's what you're taught in law school. Plaintiff, defendant, right? If a court goes down that road, right, especially a constitutional court, there's a potential for the standard zero-sum outcome. One party wins, one party loses, and you don't learn a hell of a lot, and you don't get a great deal of normative legitimacy. But if you start to follow what the court's been doing in a lot of cases, especially the meaningful engagement cases, what you see is, and you see it in lower courts as well.
What kind of cases? Can you mention one case? What do you
meaningful engagement cases. Judge level 1 and Judge level 2 are my favorite examples of how the court operated. Do you want me to describe it quickly? Because I can, because it really shows you how powerful the court can be.
Yeah, if you could just 1 minute, because I have a burning question which I'm dying to ask.
Let me finish with them.
Sure.
Because and the reason why it's so important is that these disputes are generally polycentric disputes, right? They come
what does that mean?
Polycentric, right? That means there are generally more than one or two players at the table. That is, the people that are affected by a given piece of litigation, however it's come up through the legal system. There are a large number of parties, whether they're civil society actors, other government actors at different levels, If it's a case involving a government, it might not be, it could be a party on party.
So for example, the e-toll case would be the kind of example, would that?
It could be, I mean, it could be depending upon the number of parties who participate, who are invited by the court often, either to intervene as interveners or as NGOs to give, you know, Brandeis briefs, which give the social factual background for a particular case, and mostly for a particular problem. So when the court starts to do this, and it does it at a very high level often, and also at the level of what I call participatory bubbles. When the court starts to do this, it makes up for two things that courts often lack, or often suffer from: informational deficit and normative legitimacy. Right? Normative legitimacy is a big problem for the courts in South Africa. Only 30%, the Constitutional Court, if you read the stats, has only enjoyed 30% approval, right? But the more people you allow into a court-initiated litigation process, the higher the legitimacy is going to be. You may not win, but if the court asks you and other people to repair, as they have, to a settlement table, right, where they can air their views in a way that's negotiated, where people are forced to listen and to try to work out what might be called in economic language a Pareto optimal solution, which the court can then, if it likes, if it fits the normative framework the court has set out, it can ratify and say, go ahead, run with that, and come back to us with a report as to how you're doing down the line.
So now, I mean, I'm following. I've seen a number of cases. I mean, one I remember correctly when there were xenophobic attacks, and a few years ago, the court in one case actually took that approach. But Justice O'Regan, as Stuart was speaking about this and the various methods the courts try to bring about the resolution of disputes, I wanted to ask the judge, how do you react to the term activist judge? People have always often characterized certain judges as activist judges. So how do you react to that characterization?
Well, I mean, it's a very popular term. I don't think it really says much myself. I think judges' task is not to be activist or not to be not activist, but is to sort of uphold the law and apply the Constitution. I think activist judge came out very much of the American experience in the sort of 60s and 70s, and the idea that courts ought to be developing the Constitution beyond text, etc., etc. That's not really been. We have a very modern text. We don't actually need any more than our text. So I would have absolutely, I don't like the phrase really, and I certainly wouldn't want to be described as an activist judge. But I think that judges' tasks, you should be active in supporting the Constitution, but judges should not go beyond the appropriate limits of the judicial law.
Now, you, I think both of you have publicly said that you are textual, and by that I mean that you believe in the adherence to the text and in constitutional interpretation. But having said that, I would be interested to hear from you in one of the recent cases from the Constitutional Court in Glenister, where the court invalidated a piece of legislation in ways that some commentators have said that there was not really a textual basis upon which to invalidate that piece of legislation. Could you comment on Glenister, or your views on Glenister's view from the basis as a text?
Yes. I mean, Glenister was the case which held that the legislation establishing the Hawks was not consistent with the Constitution because it didn't adequately provide for the independence of that body in relation to their corruption-fighting tasks. There's a majority opinion and a minority opinion. The minority opinion was written by Chief Justice Norwell, as he then was, and the majority opinion was written by Justice DC J. Moseneke and Cameron. What's very interesting about it, I think, is that the difference of opinion between the two was really over whether they thought that the legislation establishing the hawks provided for independence or not. It's not actually, if you read it carefully, over what they think the constitutional, what the Constitution says about this. Justice Moseneke and Cameron take the view that Section 7.2 of the Constitution, which says the state has a duty to promote, fulfill, and uphold the rights in the Bill of Rights, includes a duty to establish an anti-corruption agency that's independent. Justice Mlobo, in a passage which I think is much less remarked upon, says that Section 205 of the Constitution, which is the provision which establishes the police, says that the police must be able to fight crime effectively. And a necessary part of fighting corruption effectively, says Justice Mlobo, is that the anti-corruption agency be independent. So both of them source a constitutional obligation to independence of the corruption agency, but they really differ on whether in fact there was adequate protection for independence. And so I think that there's my instinctive preference is for focusing on Section 205, as Justice Norwood did, but then we could have a debate about whether we are happy with independence or not, and there I probably have an instinctive preference for the position taken by the majority. But it has come out in a lot of the commentary as the majority going off on this sort of tangent, saying the Constitution's got, they're creating a constitutional right to an independent corruption agency, but actually if you read the minority statement by Justice Norwood, he accepts, because of the provisions of Section 205, that it does need to be independent, but he just differs on whether it's independent or not. Now, just to go back to your textual thing very briefly, I'm not a naive textualist. Words are at times open textured, and we can reasonably disagree on what they mean. But I do believe that the starting point for any court is the text, and particularly a constitutional text. And we shouldn't be too ridiculous about this. Texts do have meanings. It does have a real meaning, and it's the size of the penumbra of disagreement varies depending on the provision. So we need to recognize that. I also think that the method adopted by our Constitution to create a set of overarching principles, which it does in Section 1 and to an extent in the preamble, which says these are the values of our Constitution, the values of non-racialism, non-sexism, the values of openness and responsiveness in government. These enable you to determine meaning where there is a penumbra of meaning, because whatever you do to establish the meaning, it's got to give effect to those values. So it's almost like a 1-2. It's not just language on the page, it's language with a particular slant, and that slant is provided by the text itself. So I think that there are times when the text isn't determinative. I accept that, but then the first port of call is Section 1 in the preamble, and I think the Constitutional Court has done that very often. But if courts let go, start feeling that they can make language mean what they want it to mean, then you're really asserting a power to effectively legislate. And Constitutional Court doesn't actually have to do that, because it's enormously wide powers to strike legislation down. What it shouldn't do is be playing with the games with the text in the Constitution.
So the words in the Constitution are important. I think that's the message that I am getting from the justice. We must start with the words. Stu, what's your take on that?
I'll answer your questions. An article I handed out called Law, Power, and Margin. One of the basic presuppositions is 99.9% of the time, you and I understand exactly what we're talking about. Words don't have this fuzziness, right? We know they have a certain meaning. I don't like the term penumbra. It's H.L.A. Hart's misunderstanding of ordinary language philosophy. There are, however, once you move past what we mostly agree on, this is a glass, this is a bottle, these are glasses, and we could do that, for the rest of the lecture, and we'd all agree on the propositions I'm stating in words. The difference with the Constitution, of course, is that it does deal with words at what I call the margin. That 0.01%, where there's actual power at play here, where there's something at stake, and where there's reason to differ. Not for grammatical reasons, not for etymological reasons, but because of the outcome itself. And the Constitution, invariably, the Constitution was a negotiated settlement, both in its interim and its final formation. So it's important to understand, it's still a political document, and there will be power and politics at the margin. But if you want my view, generally, on how you should do constitutional interpretation, let me just read from someone who I have a great admiration for. I'm persuaded by the writing of Professor Charles Black, an American professor of constitutional law, who recognized that constitutions, by their very nature, establish systems of government that need to be interpreted coherently in the light of the overall structure established. Text is important, but understanding the framework and structure of the overall scheme is as important. And that was written by probably one of our finest constitutional court judges, Cato Reagan, 5 or 6 years ago. And I don't think she's changed. I wouldn't change. I wouldn't defer. I was taught by Charles Black. And I think she's spot on. And the court, maybe, can I say one interesting thing about Glenister?
Sure.
Which I can do as an academic and which a former justice and sitting judge may not feel less comfortable. It's a very interesting judgment. Split decision. The former Chief Justice's decision looks like it was the majority decision up until the very last moment. Which explains why it reads so well and coherently, whereas the majority judgment reads like a bit of a jumble. But no matter. Not a bad outcome in either case, and I think what Justice O'Regan has pointed to that's of greater significance, whether you like the outcome or not, is that you can find sources for the notion of an independent, effective security service in both the minority judgment and the majority judgment. How they get there, the fact that they get there through different routes is of little consequence to me, right? Because I'm an academic, my job is just to try to make sense of them. But I think what's important in terms of what Justice O'Regan said is that both of them were able to locate that proposition that I just articulated, whatever the outcome might be, in the text of the Constitution. And more importantly, final note, she reaches back to Section 1. And Section 1 plays a critical role in the court's jurisprudence, especially with respect to the rule of law doctrines. Both the narrow rule of law doctrines, narrow rule of law doctrine that applies, and also sometimes the very substantive rule of law doctrines it articulates in cases like Motorclip and in Glenister. Glenister is not a Section 1 case, but you can see the two authors of that judgment using 7.2 very much as our first court would have been inclined to use Section 1. And that's all I got.
Right. That's an interesting take on Glenister. But since Stu started reading from some of what you've written, I've got something of my own. And it's taken from your dissenting opinion from Kaunda versus President. And it's something that I need to ask you from. And this is what you said. You said, it is clear from the existing jurisprudence of this court that all exercise of public power is to some extent justiciable under our Constitution, but that the precise scope of the justiciability will depend on a range of factors, including the nature of the power being exercised. Given that the duty to provide diplomatic protection can only be fulfilled by government in the conduct of foreign relations, the executive branch must be afforded considerable latitude to determine how best the duty should be carried out. My question is, do you believe that there are certain questions under our constitution that are not justiciable? Because I think the point of the scope of justice was not really expanded upon, and maybe that's why you were in the dissent at that. But is that what you are trying to say in that judgment?
No. I mean, I think all exercises of public power must be lawful. So if there's any question as to whether they're lawful or not, i.e. sourced either in the Constitution or statute, if it's public power, you have to have a source for that. If there isn't a source for that, then it's justiciable. All of them, as we know from pharmaceuticals, have to be rational. That is, they have to be somewhat, it's what I call in the Helen Suzman, there must be some rhyme or reason for them. They can't be absolutely purposeless. And so that would be justiciability. All exercises of public power must be compliant with the Bill of Rights. So any exercise of public power which is in breach of the Bill of Rights, that will be justiciable. But it's not an exercise of public power that is lawful, rational, in compliance with the Bill of Rights. There will be no basis for challenging it. But what we don't have, and this is really where justiciability is often used, we don't say that there are certain forms of conduct which may never come before the courts, and that's that we don't do in our framework. But I think what we do is we open the doors to justiciability, but the way in which the tests with which you can apply, or that you apply to different forms of conduct, varies across, and the closer you are to the pure areas of the other arms of government, foreign affairs, for example, in the case of the executive, or the process of making legislation in the case of Parliament, the greater the ambit the Constitutional Court will give them, or the greater ambit the Constitution gives them, and the grounds for justiciability therefore are fairly limited. But then there are grounds for justiciability nevertheless.
Let me put it this way. There are some constitutional scholars who make this proposition, that there are certain questions of constitutional law that the Constitution itself commits those questions to the various branches of government, and that in relation to those questions, that those branches of government have the final say, so to speak, in relation to how those matters have to be dealt with, and that if there's any disputes around those provisions, that those branches of government, that the court should not enter itself into adjudicate upon those questions, because they should respect the separation of powers and allow the elected branches of government to resolve those matters that may arise. And so it's from that point of view that I want to find out whether you think that there's any of that in terms of our Constitution.
I mean, that's a very American doctrine, if I might say. I'm sure Stuart will correct me if I put it wrong, but I think it is anyway. And we just
300 million bucks.
we don't adopt the same hands-off approach for the coordinate arms of government as they call it in constitutional law. But it doesn't mean that there isn't respect for the other arms of government. Take the amnesty power. That was the first time the issue came before the Constitutional Court. And this was the President's power to grant amnesty to and pardons to certain prisoners. Now, in many legal systems, the scope for justiciability of that decision is scant if it exists at all. But under our constitutional framework, the court said in Hugo, no, you may not, it's got to be compliant with the Bill of Rights, and subsequently in, I may have forgotten for a moment, but anyway, there's got to be fair process in relation to these decisions. So there is more justiciability in relation to that in South Africa, I think, than there would be in some other jurisdictions. But that really flows from our text, which has this very strong supremacy clause, which says that all law or conduct must comply with the Constitution, and if it doesn't, it is invalid, and the Constitution Court shall declare it invalid under Section 172. So it's a very strong supremacy clause, which is not always to be found in other constitutional frameworks. And that's back to the text. We determine the role of the courts from our text, not from what other people do in terms of their texts.
But I disagree. I think it's not an American doctrine. I think it's a doctrine that, in my view, its genesis is the principle of separation of powers. And the separation of powers, in my view, is not an American concept. It's a universal concept. But I hear your distress in relation to what the text of South African Constitution says. But Stu, what's your take on that?
Which question do you want me to answer? I think Justice Reagan's right. One must be chary when one's doing comparative constitutional law. Different systems have different histories. And they go through, we haven't had as much time to have vacillations in terms of people on the bench, expanding or contracting different views of what constitutes a justiciable matter. I think Frank Michelman argued persuasively, to my mind, years ago, when he said there's no matter which is non-constitutionally justiciable if the Constitutional Court decides to make it so. I don't want to take time fleshing out Professor Michelman's point, but he locates the basis for his conclusion in multiple sections of this text, where, as Justice Reagan rightly said, is where you start. But again, as he notes, judges may decide, and Kunda is an interesting case that you brought up, because Kunda follows after Muhammad. Now, for people like me who are really interested in extraterritorial application, if you want me to define that, I will. No. Okay, means that the Constitution applies outside South Africa's border. It's not a standard proposition in constitutional law elsewhere around the world. Muhammad has said it does. Once you've entered there, once you somehow touch South Africa in some sort of way, Constitution applies, boom. Kunda is a two-step, it's a one-step forward, two-step back if you look at Muhammad and Kunda. Kunda pulls back a little bit. And I have no idea. I'm not a member of the court. I have no idea what went into the logic behind the court's thinking. And I wouldn't ask Justice Reagan to share that with us. But it pulls back and says, look, there are limits. There are limits to how far we'll go, whereas we were willing to interfere to some extent with executive power. In Muhammad, we were willing to send a brief of sorts to the district court in New York, the federal district court that was hearing the Muhammad case. In Kunda, it steps back a little bit. And it may be, for reasons that courts often do, they're feeling their way through. There is something to the one case at a time thesis of Cass Sunstein. Sometimes you can't foresee all the potential facts that might come up when you're looking at a particular provision of law. So you try your best, but second time round in Kunda, it might have thought, you know what? Maybe the door of Muhammad was open a little too far. Maybe that's not the proposition of Muhammad, right?
Right.
The court commits itself to, that there is this extraterritorial application, is not one we want to follow all the way down the logical line. I don't know. I just read what's written.
Right. That's all we do. But if I have one question, is it objectionable to call a judge counter-revolutionary?
Is it objective?
Is it objectionable? Yeah.
I don't know, if you write a blog, I guess you can write anything in a blog. Counter-revolution. Well, I mean, those are the kinds of phrases, or I know one, in the thrall of a neoliberal framework, which was actually used by a blogger to describe our esteemed justice after a particularly important case. No, those terms are entirely unhelpful because all they are bumper stickers. To call Justice O'Regan after a particular judgment somehow in the thrall of the neoliberal Washington consensus framework, it's not good journalism, and in the case of this academic, it certainly wasn't good scholarship.
So you would say it's not. But Justice O'Regan, I wanted to ask you, I mean, you spent many years on the court. Is there any one case that you, that stands out that you like to talk to us about?
Not really. I mean, people often ask that question, but you know, it goes by in a bit of blur, frankly. And every case is utterly intriguing when you're hearing it. There's no case that you think this isn't interesting. Some of them don't have the great sort of attention of the broader public or even of the academy. But I find each legal problem presented by a case intriguing and difficult and challenging. So I can't really select one out.
Okay, well, thank you. At this point, I want to open this discussion to the audience, and so we can also hear what you have to say, comments or questions. So we do have a roving mic, I believe. If you could pass it around, and then I will point out the people who have something to say so that we can continue this conversation. If you have something, there's a mic here, so please put up your hand. Yes, there's a hand there. If you don't put up your hand, I will point at you. Okay, there's another one in the middle here.
Good evening, Justice O'Regan and Stu. I know you don't know me, but I'm Zozo.
Hi, Zozo.
You should remember, we've been emailing each other from
right.
SHHR. I want to ask a question from both of you. That is, if Justice O'Regan agrees with Stu. Stu, you suggested in one of your articles that one should sometimes seek justice elsewhere. And how can this be done? What can these alternatives be? Because you say there are other alternatives. And as people will go to courts to win. So if we seek justice elsewhere, how can this play out? And if Justice O'Regan agrees, how can this be done?
Okay, let's take another one, and then I'll give the chance for our panelists to speak. There's the one in the middle here.
Okay, good evening, everybody. My question is to Justice. There's been a lot of advocating by the court itself regarding judicial independence. And quite frankly, lately we've experienced judges being their own worst enemy surrounding the concept, especially the Nicholson judgment, the infamous Nicholson in Durban, and the squabble also regarding the Constitutional Court judges and Judge Hlophe. The question is there any merit to the term counter-revolutionary judges, whatever it may mean, if it means anything, regarding what I've just raised now?
All right, I'll give
well, to answer the first question, you know, my sort of rearing in the law was as a trade union lawyer in the 1980s, and law was only one of the strategies that a trade union would pursue in order to promote the interests of workers. And I think that's actually the truth for most litigators. There are a range of strategies that you have, and in the area of many rights issues, there are many political strategies. And I do think that we need to think about those. We also need to think about generating solutions without necessarily getting determinations by courts. So yes, I do think that we have to think creatively and innovatively about how to find solutions to particular issues that we face right across the legal spectrum and right across the social and economic spectrum. And the danger, I think, I often say to law students is that, there's the old aphorism that if all you've got is a hammer, then everything looks like a nail. So if you're a lawyer, you think the obvious thing to do is litigate. Well, actually, it probably isn't. And therefore, listening to your clients, thinking through whether there are other ways in which your client's interests can be served, which may be a lot cheaper, don't involve expensive lawyers, perhaps quicker, don't involve 4 years going to the Constitutional Court, and may even last longer if you can get an agreement with the other side, are always worth pursuing. In fact, most most cases are better with thinking strategically around why you're litigating always. So, in the answer to your question, I firmly agree with Professor Woolman on that, and I think we need to think creatively. I'm not sure that I really understand your question. I think that the judicial independence is very important. The human beings generally are not good with power, not any of us. And one of the great insights of constitutional democracies is recognizing that one of the best ways to control power is make sure that there isn't absolute power, to ensure that there are various checks and balances on everybody, checks and balances on courts, checks and balances on the legislature, checks and balances on the executive, and so on. So it's that recognition that that human beings aren't perfect, which is why we want to have independent courts. But I also say that, truthfully, the independence of the judiciary is within the hands of judges themselves. Nobody tells you how to decide a case. Nobody tells you whether to work hard at your case, unless you let them do so. So real core independence issues lie within the hands of judges. But that we should guard the judiciary and guard the process of independence of all our independent bodies, I have no doubt about, and that we all as citizens bear a responsibility in that area, I have no doubt about either. Inevitably, the relationship between courts and the legislature and executive is often quite tense. I had the privilege once to attend a session in the US Congress with Justice Mokoro and Justice Bader Ginsburg, when the relationship between the Supreme Court and Congress was incredibly tense, and it was just after the Schiavo affair, the Terry Schiavo affair. And if you listened to the radio stations in the morning, the things that were being said about the judges were quite unprintable. But the attitude of Judge Bader Ginsburg was absolutely right. She went to Congress, she said, I do my job, you do your job, I'm not going to call you names. Judges generally don't get into the habit of calling other people names. It's just, I think, an inappropriate thing to do. And if we get called names, I think we just continue doing our job regardless. We hold the keys to judicial independence. And I think we should always be cautious about it. And I do think that if a judge says, I'm worried about my independence, we should listen closely. It's not generally something judges do say. Judges do tend to speak in a measured tone. We have a very aggressive and unpleasant tone in our political debate, but generally that's not one you hear coming out of courts or in court or from judges, and I think that's appropriate. So that if at any stage a judge does say, I'm worried about judicial independence, I think it should be taken very seriously.
Yes, Stuart, you wanna respond to that? Yes.
Yeah, Zozo, that title has a couple of sources which help explain the conclusions I reached. One, it was advice given, seek justice elsewhere, advice given by Professor Ian Curry at a bachelor party roughly a decade ago. I won't name the bachelor, or that bachelor at the time, but it was about arguments. And Ian is always hippie, unlike me, and he got it down to seek justice elsewhere. You think you're gonna win, got another thing coming. But anyway, but what is its relationship to the points I was making in that article, which was about what do you do when you have very conservative, traditional, and religious associations that discriminate on any number of different bases? What do you do when you have a constitution that's clearly committed both to a large extent of private ordering of affairs? It must be, since that's where the largest store of meaning for us comes from in our day-to-day life. It doesn't come from the Constitution. What do you do when they are engaged in practices that either some insiders or outsiders deem to be incongruent with or inconsistent with the basic principles articulated in our Constitution, right? And what I suggest is, when I say seek justice elsewhere, I'm not just thinking about my grandmother's peregrinations around the globe from the Pale of settlement in Eastern Europe all the way to Brooklyn. I'm not thinking about just moving, voting with your feet. I'm thinking about the ways in which state and non-state actors can work with associations, communities, from which we draw the better part of our meaning, to ensure that if people want to remain, and I don't believe so much in false consciousness, if people want to take a particular role in a particular community, and they know what they're doing, then I'm not going to tell them not to take that role. But if there are people within traditional or religious communities, let's say, just for starters, to make it easy, who want to be able to exit from those communities, right? Then I think our Constitution, if used creatively, right, if we use something called remedial equilibration, we can use the Constitution to say, you know what, we don't like it. This is second-class citizenship, really, within your community. We're not going to force you to change your internal rules regarding membership, voice, and exit. But if you're treating, let's say, women, for example, as second-class citizens within your community, and we have a finding, whether it's under Papuda or Section 9.4 of the Constitution, that there is unfair discrimination, we're going to say you have an obligation to ease their exit, along with the state, into some other public. It may already exist, so I'll call them sub-publics within our society that already exist, or to help create a new sub-public, which cater better to their self-understandings, as opposed to the self-understanding of the community from which they wish to exit. So to seek justice elsewhere is to say, the Constitution ought not to be used as a sledgehammer, but you can use it creatively to seek and find justice elsewhere. Right? I hope that's clear.
Yeah.
Is that clear enough?
Thank you very much, Stu. Could I, I see on this side, there's another hand on the far right. If you have a hand, please, for a comment, so I can see, so that we can coordinate you. Okay, and then in the front here. Yes, go ahead.
My question it relates to a particular critique of the CC that has been made by Professor Anton Fagan of UCT. Professor Anton Fagan takes the CC to task for the proposition that the Constitution creates a general obligation on the courts to develop the common law whenever the common law does not accord with the spirit and purport of the Bill of Rights. And for that proposition, the Constitutional Court relies on Section 392, read with Section 173. The critique by Fagan is that the claim that this general obligation is false. The obligation created by Section 392 is actually conditional. Conditional in the sense that the obligation comes in when the court is actually developing the common law. So that is the condition. So for the courts to claim that the obligation is general, it's false. It is actually conditional on the court actually already developing the common law. And that reason cannot be the obligation itself. It must be something else, an independent reason. Therefore, from all those premises, Professor Fagan concludes that the Constitution actually gives the spirit and purport of the Bill of Rights a secondary role, not actually a primary role. So I just wanted to get the views of the Justice and Professor Stuart Woolman on that argument.
Interesting question. Could you take
I disagree with Professor Fagan's understanding of the Constitution, more in the sense that I think one needs to start with the recognition that this Constitution is now the Grundnorm for the existence of any law in South Africa. No law can exist in South Africa unless it is consistent with the Constitution, whether it is common law, customary law, statutory law, anything. That's where it gets its legal binding nature, is because it is consistent with the Constitution. So the starting point when any court is applying the common law, or for that matter a statute, or for that matter customary law, is to determine, is this rule that I am applying consistent with the Constitution, or does it require development, does it require refinement in the light of the values of the Constitution? And I think to say that, to try to carve out the value of our Constitution from the area of common law is a misguided and mistaken exercise, because we're actually quite fortunate in the area of common law anyway, where the common law creates a whole range of what I call normative gaps, areas in the common law which are filled with values, which up till now have been filled with rather strange values, like what the person on the Clapham omnibus might think. This doesn't seem to me to be an appropriate place to find values for our common law. And so where the common law, so for example, wrongfulness and delict, or questions of reasonableness, or boni mores in the area of the law of contract, we should, as the Constitutional Court said in Carmichael, in a case I didn't actually participate in, recognize that the test is no longer those old-fashioned tests drawn from the Roman law of wrongfulness, the legal convictions of the community or whatever. They are the values of the Constitution. And I have to say that I know of no common law system which is more suited to be filled with a range of constitutional values than ours. I think we're very fortunate. I think the way our system works is marries with the constitutional values very well. And frankly, I don't understand Professor Fagan's concerns about it, because when a judge sits down in the area of wrongfulness to say, what are the rechtsgevoelens van die gemeenskap, I don't know where they would find that answer, particularly in South Africa in 2000, other than in the Constitution. These are indeed the convictions of our community as formulated in the Constitution. They're not always going to be determinative of only one answer. I accept that too, and then we might have a debate about what is the correct answer. But that this is a rich, express, legitimate place to find values, rather than in the, a judge's sort of sense of what might be right and what might be right, seems to me to be patent and a considerable improvement on the common law to what it was before. I've had this debate with Professor Fagan, so it won't come as any surprise to me.
I mean, I think Justice Reagan is largely right. Look, I have the utmost respect for Anton. He's one of the best legal minds that we have in South Africa. I mean, the constitutional text is probably the source of his confusion. But given how much attention he pays to specific words, you would have thought about it more. I mean, 39.2 says, when interpreting any legislation and when developing the common law, customary law, every court, tribunal, or forum must promote the spirit, purport, and objects of the Bill of Rights. So somehow there's a distinction, and again, people make mistakes when they're drafting, or they're not always clear about what they want to be done with a particular provision. And so I would say here that one should drop the notion of developing, because Justice O'Regan has pointed this out, I think, in Metro Rail.
Okay.
But, yes?
Okay.
K? I think it's in Metro
Developing.
Rail too. But I mean, there's an extent, and a very limited extent, that you're, I don't necessarily believe this is a philosophical matter, but that you're always developing the common law every time you engage the common law and hand down another common law ruling. This is the Bramblebush theory of common law that, in fact, Justice O'Regan was somewhat articulating earlier. It's complicated. But if you were to read this instead, 39.2 saying, when interpreting any piece of legislation or rule or principle of common law or customary law, every court must promote the spirit, purpose, and objects of the Bill of Rights. Then I think Professor Fagan's objections have to fall away, because then there would be a clear instruction. That is, because if a case is brought to you, right, and you're being asked, right, okay, use the spirit and purpose and objects of the Bill of Rights to interpret the common law, as entangled a mess as it may be. Well, you've got no choice. It's an imperative, as Justice O'Regan says, to use the Bill of Rights to understand it. You may decide to leave the law as it stands unchanged. You may say the common law as it currently stands is consistent with the Bill of Rights. But I don't think any court with constitutional jurisdiction, whether it's a high court, the Supreme Court of Appeal, or the Constitutional Court, can avoid using the Bill of Rights if it's asked to interpret a common law dispute and if it's rightfully exercising jurisdiction in that matter. So I don't, except from the desire to keep the common law as it stands, because some courts don't know what they're doing, is the underlying presupposition, I don't understand Professor Fagan's point.
Thank you very much. There's a hand here, gentleman in the front. Yeah, thank you.
Thank you. Professor Woolman, you made an interesting point earlier on, and you were saying we hadn't had a lot of time for our bench to have an expanding or contracting kind of definitions of what's justiciable. And I wondered if you'd read the joint liaison, the KZN joint liaison case. And there was a rather stark divide, I think, in that case. And I just wanted to hear your thoughts. Maybe, do you think the Constitutional Court is currently in a period where it's starting to undergo possibly a flux like that?
A political flux? You want me to wade into those waters?
Yeah, go ahead.
You want me to wade into those waters? This one makes it a little bit more interesting.
No, I want you to respond to this question.
Let me give you an answer indirectly before I give you a direct answer. Justice O'Regan mentioned that she had time to spend with Justice Ruth Bader Ginsburg of the U.S. Supreme Court. Not too long ago. In any case, Justice Ginsburg has taken over the past decade to start her reading her dissents out loud. If you followed the U.S. Supreme Court, you know it's become significantly more conservative, and that there's a block of 5 conservative justices who wield enormous amount of power. Now, Justice Ginsburg has said, you know, in the past, I could work with Justice Rehnquist, very conservative justice. We could talk, we could work things out, right? We could maybe even find a middle ground, right, that would do more justice, right? She said, effectively, that's no longer the case. There are members of the court who are not interested in engaging me in discussion of matters of great moment, And the only thing I can do to articulate my displeasure is to actually do something that, because of the collegial nature, as the Justice knows, of a constitutional court, a Supreme Court, the only thing she could do to register her discomfort with the way she was being treated as a colleague was to begin to read her dissents out loud. Okay, so courts change, their personnel changes. Things which might have not have been up in the air under a previous court. You could call it the Chaskelson Court, you can call it the Longa Court, you could call it the Inhobo Court, what have you. May all of a sudden be up in the air in ways that you hadn't previously expected. And that's my, is that sufficiently direct a response? Would you like more?
I think I understand you.
Yeah, any other hands in the back?
No, it's a bit off topic.
Yes, that's fine.
I'd like a question of interest, a question of constitutionality perhaps of a piece of legislation. I don't know whether it's the appropriate time to ask, and that's why I thought. But I'll ask it now anyway. I was like sitting around the other day with my friends, like having a glass of wine, and we were talking about like who we vote for and who we're going to vote for in the next elections. And it came around to my turn to speak, and I mean, I'm not ashamed of it. I'll vote. I put a big fat X through my ballot box every time I vote for my own reasons, which might be obvious to everyone or not, but that's not the point. And then I was thinking maybe, like, is it possible to argue that the Electoral Act is unconstitutional because it doesn't give voice to people who want to participate through voting for no one actively? So is it possible to argue, because like the way I understand the electoral system is that, so there's a multi-party proportional representation, and say 60% vote for the ANC and 25%, let's say, vote for the DA. It's not that that 60% exactly will end up being in Parliament, because there's that 5%, let's assume for argument's sake, that of people that intentionally spoil their ballots. That 60% and that 25% will get inflated to make up that extra 5%, assuming that people had intentionally spoiled their ballots. Now I'm thinking, is it possible to argue that the Electoral Act and our electoral system is unconstitutional to people like me, who really want to vote for no one and have absolutely no one sitting in Parliament representing what I want. I want no one to be speaking for me because I don't believe in anyone in Parliament at the moment. And I was thinking, if that's the way that the Electoral Act actually works, then that's blatantly unconstitutional, because my right to participate in democracy should surely include, through Section 19 or through any other means, I mean, the Constitution itself says a multi-party proportional representation, I think. And if it does, like, surely I have the right to have no one sitting in Parliament for me when they're all wasting their time.
But thank you for that.
I guarantee you have no one in Parliament.
But I want no one there. I want a positive zero there.
You wanna take a stab at this?
It's a noble argument, but I wouldn't mortgage the house.
I'll take it if you brief me. Can I give it just a quick, slightly glib answer? I mean, there are multiple forms, and Justice O'Regan pointed to this earlier when she talked about the relationship between the Constitutional Court, law schools, and lawyers. She said, if you think democracy is primarily to be found in the Constitutional Court in 30 judgments a year, well, you're looking in the wrong place. That's not where democracy happens. We have a society where there are 6,000 assemblies and protests a year. There's a hell of a lot of participatory democracy occurring on the streets of South Africa. People are voting vocally and with their feet about different issues which affect them and the broader society. And we have a constitution, and Justice O'Regan has a slew of judgments, Masando being one that comes most immediately to mind, which speak to the fact that we have different forms of democracy, right? And representative democracy is but one of them. and it's you know, it has its flaws, it has its limitations. I've recently written about freedom of assembly as a right to stand outside the Constitution and perhaps a constitutional right to rebellion. So you've got plenty of rights in this wonderful text that give you the right to represent yourself and views. And if you want to go waste a ballot, go for it. But you know, if you want to also find a couple of people who share your views about non-representation in Parliament, there's no reason you can't take up a few placards and find an open space and get your photo in the Citizen or the Star.
Will you join my party?
What?
Will you join my party?
Probably not, no. No.
Can I ask something, Stu? Is there anything that you disagree with Justice O'Regan about? I mean, she's written a lot of judgments, and you've commented on a lot of them. You've criticized many of the judgments. But I'm particularly interested if there's any judgment that she has written or article that you don't agree with.
I'm going back to that 99.99% thing. Most of the things that Justice O'Regan, I believe, are both true, well, we agree upon, and are true. If we have a disagreement, it's going to be very much at the margin. I am going to say one area, and I think it's you know, this is the area of metaphysics, but no, not unimportant for constitutional jurisprudence. And she might rethink it after she reads my book. But in any case, you know, in Jordan, she writes, it's one of the bad, where I think there are a couple of bad judgments, and I think Jordan is one of them. And the reason I think Jordan is a bad judgment, and even in her dissent with Justice Sachs, doesn't move far enough away from the majority, is the notion that sex workers or prostitutes actually exercise some significant degree of autonomy over their lives, right? Which makes them effectively culpable, right, under law for the crimes that they commit in terms of our law. Well, for reasons, again, for metaphysical reasons that I spin out, I do not think, well, I'm a determinist for starters, and secondly, if you're looking at most sex workers, they are predominantly a function of sexual trafficking, which is a huge problem in South Africa, whether they're women or children. And to attribute to them autonomy and an understanding of the stigma that attaches to their work, I think fails to understand that a significant segment of our population has no choice in life's great wheel of fortune. And that that's the only thing I can think of in her entire oeuvre of writing. And remember, she writes the majority judgment in Jordan. And it's a little metaphysical point, but I think a lot turns on it.
It's a dissenting judgment, but I agree with you. But how do you distinguish that from the law of theft?
In terms, you don't want to get into this now.
No,
but I mean, I think, well, I mean, yeah, you're right. You're right. I mean, if people
Why do you
are,
not destroy
hell yeah. I mean,
inside?
quite frankly, if you had to ask me in a society as stratified and as unsustainable as the World Bank called us before Maracana last year, where 12 million people in our country suffer from starvation or malnutrition. If someone steals my car, well, you know, it's a movable feast in South Africa.
So that's unconstitutional too.
What?
Law of theft. I mean, you have to.
Well, no, I didn't say that. No, I didn't say that. I didn't say that. I said there are some things for which my conclusion would be, look, and I don't want to take a utilitarian view of it because it's more complex. We have systems of law which are designed to, right, promote certain kinds of behavior and suggest that other kinds of behavior are undesirable, right? Now, am I giving a free pass to sex workers that I wouldn't give to thieves? I'm going to look at them differently. In an article I wrote at the time, I said, well, the judges don't seem to be realize that in their everyday work, they're commodifying their bodies too. But I haven't heard anyone take me up. I said part. I didn't say which part. I said part of your body, and it was about commodification. And that was the problem with sex workers, that they were commodifying this particular part of their body. Look, you have to. I believe in a system of law, and I believe you justify it as best as you possibly can. And I think if you're really concerned about law and constitutional law, which creates the conditions for freedom, then you have to really, more than arguments about thieves and prostitutes, you have to address yourself metaphysically and physically to the places where real freedom doesn't exist. Right? Food, water, housing, jobs, education. Metaphysics, nice. You can believe in free will or not. If you really want to talk about freedom, let's talk about what freedom really means. Right? And having those basic goods that make a life worth pursuing valuable. Okay?
Any comment? I know you wanted to say a little bit more.
I just think these are very difficult things, and I think I mean, it's clear when you read your book that the dissent that Justice Sachs and I wrote, we thought was going to be majority judgments. We wrote in a way which we thought was dissent proof, but boy, were we wrong. And it would have been probably a very different judgment if we knew we were writing dissent. And it is a very difficult area, because I think it's difficult to say, the Constitution needs to acknowledge that people do have autonomy in certain areas, and in certain areas they don't, and to, if wherever we can, to foster the possibility of autonomy. So it's, I have to be honest, I have said in other occasions there are 2 or 3 paragraphs in Jordan that I would like to erase. So you perhaps have heard that and say that, but there are. But it was mostly written because we thought we need to do it to be able to get majority. We ended up being, I mean, I still find it surprising that they took the view they did, which was okay to criminalise the prostitute but not the client. And that was a surprise to me. But yeah, you know, given the thousands of paragraphs, I suppose.
If that's it. And now I've got a chance to make a little notation before it's finally done to say that you would have written it.
Yeah. I'll tell you the paragraphs if we're going to be very precise about that.
No, we'll get there.
Okay. There's another hand out there. Join in the conversation.
If there's no other, okay. To ask what probably at first blush might sound like a first-year law student question to both panelists. Can lower court judges be said to act unconstitutionally in the legitimate exercise of their functions? And let me expand on that a little bit. I just want to put the question out there. So to connect it firstly to the conversation that we've been having, I mean, it was interesting when we're talking about the common law and a point that Stu made about the courts particularly the appeal courts being a lot softer on lower courts or being more deferential to lower courts in interpretations of the common law and the common law than they are with respect to legislation. So where courts get it obviously wrong, is there that possibility? Then I'll go more pointedly to a particular case whose facts I think a lot of us will be familiar with, the outer case, where in the Concord appeal, against the interim interdict, Justice Mseneke comes down quite hard on Justice Prinsloo for his complete failure to take into consideration the separation of powers arguments that were made at the High Court. And one could, at a stretch, maybe, or it would become a little bit adventurous, talk of it as a potential dereliction of duty. That if it was a member of the of the other branches, a member of government that had completely failed to exercise their power in a way that they were expected to exercise their power, I don't think the courts would have had too much difficulty in calling that particular exercise of power unconstitutional. Then the third strand, really, where I started to think of these questions is I had the opportunity recently to meet the president of the Ecuadorian Constitutional Court. And that was quite interesting because their constitutional court, the structure is somewhat different. Things could have been lost in translation. We had a translator. But from my understanding, their constitutional court sits not as a part of the court structure, but it sits as essentially an independent court that's primarily concerned with constitutional questions and doesn't sit as an ordinary court of appeal. So it will make calls on the constitutionality of decisions of the court. So constitutional court decisions can be declared to be unconstitutional, conduct of the president and so forth and so forth. So there goes my first year question. Can lower courts be said to act unconstitutionally in the legitimate exercise of their functions? What would your thoughts be on that?
Well, in relation to actual decision making, of course, our whole legal system is premised on the possibility of judicial fallibility, and that's why we have appeals. We don't do the same with the legislature or the executive. In other words, there's no process of appealing except in administrative law. But so it seems to me that the system is designed to ensure that there's relooks at the actual decision-making processes and the outcomes. Courts below. And I don't think it's necessarily helpful to talk about it as unconstitutional law. And I actually thought Judge Prinsloo, I mean, talking to my colleagues who sit in the High Court who get, a pile of files like this on a Monday morning and, phalanx of counsel, and now they have been allocated precisely 5 minutes preparation time before they have to go to court and they have to get a judgment out. It's quite tough to call the odds there. I think that their job is to get a judgment out. Of course, from time to time, as I say, the system's built on the possibility of appealing because you can be fallible. So I think I wouldn't say that Judge Prinsloo had so mightily overstepped the mark that one would go the way you're suggesting. But generally, I wouldn't go there. I think we have appeals precisely to correct errors made by courts below. I would like for courts to acknowledge more than perhaps we do in the way in which we deal with members of the public and witnesses and accused persons and so on, that that they are entitled to be treated with respect in the court system and so on. I'd like to see more work done like that. I think courts are starting to do that, but again, the tales told I hear of experiences in magistrates and courts and so on where people don't necessarily get treated very well by the courts per se. One would really like to see that changed. And again, I don't think that's the sort of thing where it's mostly systemic, like a lot of our problems with government. It's not one particular bad example, it's just the way things happen all the time. Understaffing, not good systems set in place and that kind of thing. So I can't see it really developing necessarily into a case. But I would like the courts to acknowledge that they are bound by the Constitution and duty-bound to acknowledge the rights in the ways in which they deal with people. So that people go into a court, they have some sense of the value which the Constitution places on respect for each and every citizen.
Stu, you want to answer that question?
You heard enough, Sally, or you know more? I mean, separation of powers as a doctrine is, it's often a rhetorical device. If I'm jumping past the first stage question, the moving past Justice O'Regan's analysis, I mean, just well, to stop there for a moment, our process allows for multiple opportunities to revisit judgments, whether it's going up the review process, whether after, even if the Constitutional Court has found something unconstitutional, the legislature surely has another crack. Right? Our system is such, because of the way our Bill of Rights is structured, often has another crack at writing different legislation than the Constitutional Court might have in mind, but that's constitutionally compliant. And of course, the body politic has the opportunity to amend the Constitution if it finds that particular sets of judgments are anathema to it. So, there's no reason, I guess, to find a lower court justice's opinion unconstitutional. Other jurisdictions have outs, like the Canadians do with Section 1. They can actually say, boom, something's not for constitutional review. But aside, is it Section 1 or Section 36? Anyway, yeah, on the first question, I think there's plenty of opportunities if a judge makes a mistake to get it right, either through the judicial system or through the legislature or the executive. On separation of powers, I think I don't think I have anything more to say than that it's often a rhetorical device used within the court itself to limit or expand its powers as it sees fit, and it's often a rhetorical device used by the executive or the legislature when it thinks that another branch is stepping on its toes in a particular way. That's, I think, separation of powers has been around since Montesquieu, and it serves us well.
I see two questions. I think we'll take two last questions and then we'll call it. So I think if you can give, they're right next to you, sir.
I'm happy the Justice brought out the point that perhaps litigation is not always the answer. I absolutely agree. But one professor who might or might not be wearing a blue shirt this evening once raised a point and said something to the effect of a large contingent of our citizens is uneducated, and for that reason they do not appreciate what happens around them. For that reason they do not hold the government to account. And if that is indeed the case, we must then reject your view, Professor Stu, to the effect that people must vote with their feet because they're not even conscious of the problems around them. Then the question becomes, in an event that is the case, how do the 2-3 people that are conscious and are educated about politics and the law use the law, dare I say, and politics to bring meaningful change?
We'll take the last question. And maybe later on you can identify who that professor was.
Good evening, Professor Woolman and Justice O'Regan. My name is Tepo, and I want to, it's an attempt, and I hope you give me some merit for that, to elevate what I believe is a legitimate concern that was raised by Mr. Sibanda, that and I want to suggest at the very outset that it seems that you're equating a mistake like misinterpretation with a blatant disregard of the Constitution, I want to suggest. And I believe there is some merit to that concern, because you find in many judgments what may be called conservative judges who frustrate the process of constitutionalizing, and I use that word loosely because I've recently come to learn that it's very ambiguous, but frustrate that process of many of these common law principles which have not been yet constitutionalized yet. So what happens is you find either, on the one hand, judges reciting principles of the Constitution without necessarily or genuinely applying them, to say, I've done my job, I've recognized it, or not recognizing them at all. And in that sense, I think when judges do, if I understood the concern correctly, I think that is extremely unconstitutional. And I think the concern has some merit. It's not a mistake. Or if it is a mistake, it's got very serious consequences for all of our law and our society. So I want you, with respect, to readdress the concern. Thank you.
Okay.
It's not that law isn't sometimes useful in these pursuits, but in a kind of a way, constitutions are constitutional because each new generation believes they should be our constitution. And if there's one thing that does worry me about our debate in South Africa is that we tend to use a lot of slogans and not a lot of content. And one of the slogans that we're using quite a lot involves challenges to the Constitution, which I still believe provides an extraordinarily insightful roadmap for transformation in South Africa. And I think as lawyers we need to communicate that and we need to analyse that. Maybe there are problems with it, maybe there are areas we need to think about it. But every single new generation needs to do this task. We can't just say because it was done before we can now hang up our boots and give over, because constitutions continue to be the live documents that they are, giving guidance to a society because each new generation accepts them. And although it is true that we have enormous diversity in South African society, real problems with our education system, it doesn't mean that these ideas can't be communicated broadly and widely to South African citizens. And I think we all bear a responsibility to do that. In relation to the second question, I think adjudicating this constitution is tough. It's not business as usual. It requires a lot of care and thought, and it's easy to get things wrong. I've just admitted that there's passages of my jurisprudence which I had lots of time to think about, where, I wouldn't mind having it, even though it is only one.
At least I got it right.
It's not easy, and for courts, for busy High Court judges who are facing a busy opposed motion role, it's particularly hard. It's also hard if the case is not well argued before them, which so often what happens in the Constitutional Court, you look at what the judgment below was, and then you find that there's a whole new legal team that's arrived who are doing a very different job to what was done below. So I wouldn't automatically say that the judges are intentionally not doing it. I have to say, in the early days, we had several judges who, in their judgment, said, "And I would sentence you to capital punishment to those lunatics in Braamfontein hadn't just abolished the death penalty." So we were much closer. I didn't quite formulate it like that, but that was very much the tone. We were very much closer to sort of real resistance to the Constitution in the 1940 to 2000 period than I think we see now. But I've just spent the day at the Judicial Education Institute talking about the need to provide judges with education on the Constitution and constitutional litigation, because I do think it's very difficult. And for judges, who are sitting in Braamfontein with 10 other colleagues, always working with the Constitution day in, day out, having had the opportunity to read all the judgments, it's very, it's a lot easier, and generally getting the finest advocates in the country to argue before you than it is for a judge in a busy division who's dealing with the divorce one minute and the e-tolling case the next. So I also do believe, and this is my little plaintive hope, that it's always better to believe in the sort of negligence error theory than the trying to actively undermine theory of people, unless you're absolutely persuaded. Believe in people's bona fides, not saying everybody is bona fide, but start out with that belief. And my general sense is that there's been very little work done for judges of the High Court on judicial education. It's never really got up and running, the Judicial Education Institute, so we're really hoping that that will happen and that will ease the work of judges in some very busy High Courts who are facing these difficult cases quite often.
Thank you very much for that. And if I could just say that we do have a master's course in constitutional litigation, so for any of you who want to be judges in the future, I would advise you to consider it. I see a number of professors who teach that are here, so talk to me after this. I would like to suggest that we end this conversation here, but that we move this conversation into the room next door over some drinks and some refreshments. But I would like to thank Justice Reagan and Professor Woolman again for being here, and for all of you for also raising this occasion. Thank you very much.